Morning. We're really excited to present this panel and to have some audience participation, so hopefully you're all awake and eager. The panel today, as you know, is about directors and officer duties before and during crises. So we're going to talk about what directors and officers need to know to plan for and manage insolvency and other company challenges. I'll start by introducing our panelists. To my immediate right is Jim Bailey. He's a shareholder in the Bankruptcy, Restructuring, and Workouts Department here at Fredrikson and Byron. He's a nationally recognized lawyer with over 45 years of experience, mainly representing financially stressed businesses or their creditors. Nominated by his peers, he became a fellow of the American College of Bankruptcy in 1997. He has served as the president of the Hennepin County Bar Association and the Minnesota State Bar Association. More recently, he was lead attorney for the Turnaround Management Association's Upper Midwest Chapter's Transactions of the Year in 2006 and 2010, and for the TMA's National Transaction of the Year in 2009. To his right is John Stout. He's also a shareholder here at Fredrikson and Byron, focusing on business organization, finance, and governance. He's the chair of the Corporate Governance Group and the co-chair of the Corporate Sustainability and Social Responsibility Group, as well as the co-chair of the Media and Entertainment Groups. He's a recognized expert in corporate governance. In fact, in August 2011, he was appointed to serve a 3-year term as the chair of the Corporate Governance Committee of the American Bar Association's Business Law section. Then in April 2014, he was appointed to the Governing Council of the ABA's Business Law section. And in May 2014, he agreed to serve as a vice chair of the Business Law Section's Committee on Corporate Social Responsibility. John recently returned from an ABA conference in Montreal where he moderated a very well-received panel discussing the importance of governance, culture, compliance, and ethics that looked at different situations, including Enron and Volkswagen. So hopefully he will mention some of those things today as we go along. But I'm sure he'd also be happy to provide you with some of those materials if anyone has further interest. To his right, now let me double check because they switched around on me. Right. We've got Mark Sheffert. He's the chairman and CEO of Manchester Companies, Inc., which is a Minneapolis-based firm providing board governance advisory services in many areas, including board governance itself, management, dispute resolution, corporate renewal, litigation support, and performance improvement. If you look at his bio, and I should mention that the full bios are in the printed materials, so you can see more in there, but if you look at his bio, you'll see a string of letters following his name that show his extensive education and certifications, including being a certified turnaround professional and a certified board advisor. In addition to that, he's a nationally recognized business leader, advisor, and author on corporate governance issues. He has served on over 50 boards of directors, including some of the nation's largest financial, airline, healthcare, and other organizations. He's been an advisor to over 100 boards. And to mention just a couple of his recent honors, in 2009, he was awarded the Outstanding Director Lifetime Achievement Award by the National Association of Corporate Directors. And in 2014, he was inducted into the Minnesota Business Hall of Fame for his lifetime contributions to Minnesota's economy and greater community. To his right, we have John Rittell, who is a vice president of Marsh & McLennan Companies, which is a professional services firm that has a global network of 60,000 experts focusing on risk, strategy, and personnel issues. It helps organizations manage risks and make the most of their opportunities, their capital, and their people, including analyzing corporate and other insurance needs. Mr. Rittell works out of Marsh's Minneapolis office, and he's an expert in risk and loss mitigation with extensive experience in the insurance industry. He works closely with his clients, including major Minneapolis corporations, to understand their businesses and needs, then to tailor solutions to manage risk and protect against other potential crises. He has specific expertise in the healthcare arena, but his clients span many other industries, including property management, retailers, food manufacturers, and distributors. He has extensive community involvement, including serving on the board of directors of the Turnaround Management Association of Minnesota. And last and least experienced, I am Sarah Olson, a senior associate in Fredrikson's bankruptcy group. So I have the honor of working with Jim on a regular basis and have learned a lot from him and participated in some of the situations he'll mention today. So let's get going. Here's a quick overview of the things we're going to talk about today. Maybe not necessarily in this order, but these are things we're going to touch on. I'll let you kind of read through them on your own, but wanted to make a few notes about the schedule. So as you know, we've started a few minutes late to account for the parking lot issues. And we're hoping, in respect of your schedules, to conclude a little bit early. Instead of taking a break in the middle and wrapping up around 10, we're going to skip the break, try to wrap up our presentation around 9:30 so that we have time for questions and answers, and then can get you out of here hopefully a little bit early. Speaking of questions and answers, though, as I mentioned before, we hope that this is an audience participation kind of presentation. So if you have questions or thoughts and comments throughout, please don't hesitate to chime in. We do have a person who will come around with a microphone, so if you remember, that would be great if you wait until she gets to you. If not, I'll just repeat the question. So please don't be shy. And finally, included at your spot with the materials is a green form, which is an evaluation, and we are supposed to ask that you complete it at the end and turn it in as you leave. So, turn to John Stout here first, and he will provide sort of an overview of the basics that probably all of you know, but never hurts to get a refresher of director and officer duties in a normal situation, a non-crisis situation when you are just sort of going about the normal course of business. So, John?
Thanks, Sarah. Good morning, and I recognize some of you, not others. How many of you have served on boards of companies? Maybe 40% or so. So you get the whole business of director duties. They're not hard to say in terms of the statutory duties of care, loyalty, and good faith. I think those are pretty easy to understand. Care is kind of self-explanatory. Loyalty is interesting. Because in the press there's sometimes a misunderstanding of to whom the duty of loyalty is owed. And it's quite clear in Minnesota and a number of other states, maybe a little more blurred in Delaware, but it's quite clear that the duty is to the corporation and not specifically to the shareholders, except in some situations, and later on in the program, there are nuances to whom the duty is owed, and as you might guess, it sometimes depends on the corporate situation. But you can understand why it wouldn't be owed to the shareholders generally, unless you're selling the company. There's probably no unity of interest. If you think about the shareholders of some of the big corporations, there are day traders, there are short sellers, there are hedge funds with very specific agendas, some of them single issue hedge funds that want the company to take a certain action. It'd be very hard if you were a director to take into account and to have a duty of loyalty to all of those different agendas. But the nuances of that statement will be explored as we go along. And good faith is sometimes thought of as combined with the duty of loyalty, but I think it's worth talking about separately because there are other qualities to good faith, and sometimes in some companies, as some of you may know, you can actually disclaim fiduciary duties, particularly the duty of care. Often in corporations, not the duty of loyalty, and certainly in other entities where you can disclaim even loyalty, you can't disclaim the duty to act in good faith. And you can think of good faith as having an element of fairness, conscientious behavior, reasonableness, obviously an absence of conflicts, etc. And then on the second page of your slides, we talk about things that that protect directors. The business judgment rule isn't actually a law, it's a presumption that the directors have acted in accordance with their fiduciary responsibilities in making business decisions, and it simply throws on a party who wants to contest that the burden of proving that they didn't. And then you'll see the rights of directors to rely on others, and that's true as long as there's care in choosing them and the people that you're relying on are qualified to be relied on. And when you're talking about board committees, which that issue is spoken to in the statute, if the board's going to delegate its duties, you have to have something in writing that's very clear about what's being delegated. And again, the delegation has to be reasonable, and you have to be confident that the people you're putting on the committee are qualified to do what you're asking the committee to do. And then you'll see a couple of other items there. Indemnification is important, and that can be in the corporate governing documents, sometimes in the bylaws, sometimes in agreements that people have or companies have with their directors. There are statutory provisions regarding indemnification, and advancement of expenses, which actually is sometimes way more important than indemnification. But there are statutory provisions, and the big difference between them in different states is some states like Minnesota would make indemnification mandatory unless you limited it, and in a state like Delaware, it's permissive. So there has to be something that requires the company to do it, or it's not required by statute. And then there's an item that you should make a note of that is called exculpation. You can put a provision in the governing documents, particularly in the articles of incorporation, if you're dealing with a corporation, which allows the company to say, hey, directors won't have monetary liability for breach of fiduciary duty, but you have to think that through and say, as long as they don't violate the duty of loyalty or the duty to act in good faith. I want to go back quickly to the issue of duties. The statutory duties are one thing, right? But there are lots of other sources of duties. And you find them in case law, but even beyond the law, there are many places where you can find a long list of director duties. And the statutes don't require this, but I want to call particular attention, given the subject this morning, to some duties that I think there's really a triad. A lot of people will say the most important thing directors do is kind of choose the CEO and then oversee the CEO and compensate, evaluate, terminate if necessary. I don't fully agree with that. I think the most important thing boards do has to do with board composition. And we'll talk more about that in the program as we go along, but everything starts with who's on the board. The values, the skill sets, all of that, because that's the background and that's the basis for coming into choosing the CEO. The other important thing is the organization and leadership of the board. And in terms of board composition, it's important to really think through. There's a lot of conversation out there about diversity and the many forms of diversity. And I would say boards definitely shouldn't gloss over that. I've had 3 experiences where one as a lawyer, 2 on the board, where board diversity really showed up in the context that we're talking about it this morning. I was the chair of a board where the CEO decided to address some financial issues by not paying the payroll and other taxes. And I had my home liened by the Minnesota Department of Revenue, because they thought I had some significant responsibility as chairman of the board. And the organization, we had to terminate the CEO, obviously. It wasn't a very good judgment on that person's part. But we brought that organization back. And fortunately, I didn't have to pay the Department of Revenue anything personally. But we did it because on the board, we probably lost half of the board members. But we ended up with 7 or 8, and the skills of those people and the courage of those people to stand up in the face of the problems was really critical to the board. And it was a diverse board in terms of skill sets. It was, the people left were about half men and half women. They had experience with different aspects of corporate leadership, and it was really through their efforts that we were able to turn the company around and bring it back to health and help me get off the Department of Revenue's wish list. I'm going to stop there and pass it on.
Yeah, so
we can come back to some of these subjects later.
Yeah, so John's given you a good preview there of some of the types of things we'll get to. But with that kind of baseline in mind and thinking about what the normal duties are, let's turn to talking about how those duties change when crises arise, but also some sort of practical information and tips about what to do to comply with those duties in times of crisis, but also leading up to a crisis. What can a board do to prepare for a crisis? And let's turn to Mark and John to hear a bit more about that.
Okay, probably the basics are to, first of all, accept that a crisis is inevitable. In my experience, sometimes boards live in a little bit of a fiction world and believe that a crisis can never hit it. And if you think about the characteristics of board members, most board members are very successful executives or successful people in their own work life, and they've never been through a crisis, or they probably aren't on the board. There are very few ads that say great board member wanted who has crisis experience. Not exactly the kind of ad that's going to attract a really successful business person. So given the very nature of board members, there's a little bit of what I call denoidance, is a term that I coined years ago, denial and avoidance. And so it's important, given the characteristics, that the board accept the fact that a crisis can be inevitable. And then have a crisis response plan. It's becoming much more prevalent today in organizations, the risk management side of the business, and John will comment on that more in a minute. But having a response plan and know who is going to do what, who has the responsibility if we do get into a crisis, and what types of crisis might exist that would require a different response. Perhaps from outside public relations firm, or it could be management that responds, but frequently it's the board that responds, or a special committee of the board. And I can't overemphasize this, but having an effective communication plan, the time to develop a crisis communication plan is not when the crisis is there. It's to develop it well in advance, so you know exactly which phone you're going to dial and who you're going to get a hold of and who's going to be your crisis communications leader. Identify who in the organization has the risk assessment and management responsibility. Again, that's becoming more common today. That person or persons, in my opinion, should be reporting to the board at least a couple times a year and updating the board on potential risks. If for no other reason, it's good for the record that the board has had those discussions. So, John, you want to, maybe you'd like to comment on just the insurance part of it?
Sure. Yeah, just to kind of get into it. One of the things that I've experienced with dealing with the different boards is that when they think about risk and dealing with risk, they tend to look at insurance as what's covered, what do we have in place. rather than thinking about the opposite way to look at risk of what's not covered. What are the risks that we have that we aren't addressing right now, and really thinking through those. So I think as board members, you need to be, conscientious of not what we have for insurance, but what we don't have for insurance, and what risks are out there that need to be addressed through either management control practices or other means other than insurance. So I think that's kind of a critical thought process as boards think about risk and managing through it. When we think about a director and an officer of a corporation, there are several forms of insurance and several things to be thinking about. What I'd like to share is that when it comes to directors and officers liability insurance, don't be cheap. It's not a commodity. It's one of the final things that can protect you as a board member in the event of a crisis. So that's the time before a crisis occurs to really understand what kind of limits should be purchased for the organization, for you as directors and officers. I think benchmarking and really analyzing what industry that you're in and understanding the variance, because there's a significant variance across industry of the types of claims that can occur, whether you're private or a public company, and to be thinking about those items. Typically in a D&O policy, there's three kinds of coverages. It's A, B, and C. A is the reimbursement of claims against directors and officers. You've got coverage B, which reimburses the company for the claims against the D's and O's, and coverage C, which is basically the entity coverage. Those are the three things to be thinking about as a director and officer, but one of the most misunderstood or least valued is the side A coverage that protects the directors and officers specifically for those risks in the event that the indemnification provisions are not able to be fulfilled by the corporation. I've had several clients that have been through those kinds of situations and are very sensitive to their personal assets being at risk. John obviously, mentioned one of those things, and it's usually a surprise. I remember several years ago, back in the 90s, that's a long time ago, in front of a very large public corporation where we were explaining the D&O coverage, and there were a couple board members in the back of the room where I said, your personal assets were at risk in the event that something goes wrong here. And one of the older gentlemen turned white and almost walked out of the room because he really didn't realize the extent of his personal liability as a director of the company, as a board member. So really understanding those risks and managing through those. When it comes to the types of coverages that you can get in place for your insurance, again, it's not a commodity. There's a fair amount of variance and negotiation that can go in front of negotiating the policies. One of the things is the order of payments. So when you think about a claim that comes in, and D&O claims typically take a very long time to settle out. There's a lot of investigation. There's a lot of legal work that goes around it. They're very expensive claims. So understanding the order of payments to make sure that the directors and officers are first in line to get paid, not in the mix, so you can negotiate those types of things. You can negotiate predetermined pricing for tail coverage in the event that you need those types of things. Recent event with a client was they are a publicly traded company. There was a potential change in the percentage of ownership, and new board members were potentially going to be coming on. And the existing board members were concerned about being displaced. What we ended up doing was pre-negotiating a tail policy in the event of a change in control, and then a new policy would be negotiated going forward. That event did happen. It was a friendly transition. It wasn't an adversarial transition, so they didn't execute on that. But again, thinking about the things that can go wrong and the contingency planning is really important. So spending the time up front and thinking about these issues and recognizing that directors and officers liability insurance is not a commodity. There's a real value in negotiating those things up front to protect the board is extremely important. When you think about getting into the situation where you get into a turmoil situation where things start getting into the crisis, some companies will say, well, we'll just buy this amount of insurance, and if things go bad, then we'll buy more insurance later on. Well, once the crisis happens, the events are occurring, those additional limits will not apply to the things that have occurred prior to. So you're really not protecting yourself waiting, thinking you can buy a low limit because nothing's going to go wrong, and then things do go wrong and you think you can buy more limit to protect yourself. It's kind of like trying to buy insurance when the house is on fire. It's a little bit too late. So those are a couple things I want to just kind of run through from an insurance standpoint. But once the board finds themselves in crisis, then we're really trying to deal with what are the issues at hand and how to manage through that process.
Can I make a quick comment on that, John? This is a plug for you and your business. So I'm dealing with 8 directors right now who have been sued. They're in 10 different states, and they have different coverages for various reasons that apply to them. But I'll say this generally. You say to directors, well, do you have insurance? Yes, we've got D&O insurance. Do you know what it covers? Do you know what the exclusions are? Do you know what the limits are? No, they have no idea what the policies say and what their exposure is under the policies and what the process of getting their expenses advanced is. And I guess it shouldn't be shocking to me anymore, but for those of you who are serving on boards and who haven't really paid attention, and ask someone like John to sit down with the board and really go through the coverages and understand it and understand where the gaps are, it's a huge mistake. Just to say I have D&O insurance should not be sufficient for anyone to feel comfortable about what their coverages actually are.
Looks like we have
if you don't like reading the policy, then get somebody who's knowledgeable to explain it to you.
Looks like we have a question maybe about that.
Oh, John, just a quick question. Would you say the directors who don't know what their D&O coverages are usually are the directors who don't require it be in place before they become directors?
No. It's because everyone should understand it. And it's what John said. It may be too late to learn it. That is the case for several of the directors who are now paying fees personally. And if they had been properly advised and properly aware, which you have to really put it on the directors, they could have solved some of these insurance problems at the front end. But now we're in litigation, as John said, the house is on fire. And it's too late to go back to the insurance company and say, hey, could I have an endorsement that would cover this particular situation?
John, could you talk about wasting policies? I had a case where 6 different officers were sued, and they all wanted separate counsel, so the expenses racked up pretty quickly.
So what's the question is,
Are all D&O policies wasting policies?
wasting policies in terms of?
Expenses come off.
Yeah, so most of the D&O policies that you've got is defense costs. I mean, the insurance business is built around defense is either inside the limit or outside the limit. So there are policies that defense is in addition to the limit that's paid out, and some policies have defense that is inside the limit of the policy incurred. Sometimes you look at your deductibles that a policy would have, that the defense expense erodes the deductible, and sometimes they don't. So these are all negotiable things that I think you run through. And again, these are the details when you get into policies and the way they're structured that the Ds and Os need to really understand. Do they have a full limit of the indemnification that they're incurring, or is the limit subject to also all the defense costs incurred in the policy? So again, these are details and nuances that when John talks about, yeah, I have D&O insurance, but what do you really have? And I think it's important to know those differences.
The other quick comment I'd make about that is, look, a lot of the insurance policies will require collaboration and won't pay for 6 different lawyers unless there's a real difference, material difference in interest between each of those officers. So that's a problem, because underneath the D&O policy is the indemnification obligation of the company. And in your bylaws, in the company bylaws or governing documents, you have to make it clear, in my view, you have to make it clear. It's not good enough to say indemnify to the maximum extent permitted by law. That's just an open checkbook. You have to make it clear that if somebody is coming to you for indemnification, which means a D&O, they have to collaborate to the extent possible with the other Ds and Os in choosing single counsel to represent the group, unless there are conflicts that make more than one counsel necessary. So avoiding that situation is critical, not just for the insurance company, which may force it on you, but for the company itself, which will have the baseline indemnification obligation.
Just one quick question, John.
Yep.
In answering the question that was asked, is it more prevalent or more common to have limits one way or the other for expenses? Is it, because you mentioned you could tailor the policy both ways, but is one much more common than the other?
We prefer to have defense outside the limit and the indemnifications amount, excess of the defense cost, but oftentimes it is included inside the limitations.
John, just a quick comment on
Yep.
that too. My colleague John worked at directors and officers liability. More often than not, the defense costs are going to be inside the limit of liability and erode that limit. So that's something to be conscious of. The marketplace has changed where it's more common to have those inside the limits now.
And that's part of the reason we do the benchmarking and really understand what types of claims are out there by industry, because there's a fairly large variation across different industries of the size of claims that typically have. And we spend time breaking down how much of the total claim is defense and how much is indemnification. And to understand that really starts driving the types of limits that you want to purchase.
John, maybe you could comment. It's not unusual to be talking to a board of directors and ask them if they have D&O coverage, and they say yes. How much? Well, let's say there's 10 million and they have 10 directors, but they forget about the officers. Can you comment on that?
Right. Well, so what we end up doing typically is we benchmark across industry. It's not necessarily is it driven by the number of officers or directors specifically, but recognizing that the larger the company, the larger the director and officer base, is going to drive the types of limits that you purchase. So those are all the kind of various inputs that we look at in determining the appropriate limits for companies to purchase.
All right, so let's move on and talk a little bit about how a board may find itself in a crisis situation. And Mark will walk us through this, but I hope the rest of the panelists and even the audience will kind of chime in maybe with some examples they've seen in real life.
Well, I'm going to shoot through this really quick. I mean, there are a myriad of ways that an organization can find itself in trouble. Volkswagen, for instance, could probably explain that well. But obviously, there are operational issues. What we see are typically an inability to meet customer orders on time, sales force leaving, a loss of a major customer. Concentration issues are something that boards should pay a lot of attention to and often don't. Concentration of business, concentration with vendors, excessive overtime, inventory or scrap, product recalls, and so on, environmental issues. So operational issues can get a company in trouble really fast. Managerial issues, you get a resignation, death, or termination of a CEO or a COO or a CFO. I can't say enough about succession planning and making sure that all the C's and O's are covered. And the ability or the inability, doing a really good assessment of management's ability to correct financial or operational issues. A lot of times we have boards of directors tell us that, oh, we have a great management team. That management team has never been through a crisis. And do they have the experience to go through a crisis if one occurs? Disaster issues, storms, earthquakes, fires. Unfortunately, today we even have to think more about terrorists than we do natural disasters and how that may, and cyber attacks and how those may affect the business. Obviously, hostile takeover attempts or issues like third-party actions, shareholder advocacy groups starting proxy fights. John can explain this, but
One of the things that I've recently been involved with on another board that I'm a part of is the whole issue is when you get into a crisis and you're starting to look at the leadership and changing management, when does the board move from governance to management and right the ship? How does that process look, or what's your thoughts on engaging when you have maybe a crisis in leadership as much as the business?
we're going to cover that. If you can hold that.
Okay, all right, perfect.
If you could hold that for just a few minutes, I'd be glad to answer that. It's a great question. Right now, I want to talk about how a board may find itself in crisis, and just kind of finishing that up. We were talking about third parties, sort of natural things, and then third parties, and of course, disasters, terrorists, and so on. Clearly, financial issues, all of these manifest in financial issues, principally a balance sheet, income statement, liquidity, capital structure issues. Examples on balance sheet are the loss of material amounts of current assets, cash, securities, receivables, inventory, necessary to conduct the operations of the business. Even the loss of material non-current assets like plant, equipment, intellectual property, and goodwill. I'm not going to go through all these, but they're just examples. On the liability side, obviously the acquisition of sports teams, golf courses, airplanes can create a liquidity issue. On the income statement, a material decline in sources of revenue, materially greater expense if you don't have productive assets to produce. The productive assets are all three: produce lower income, cash flow, and potentially operating losses. In terms of liquidity, obviously just running out of gas, not being able to get a loan, not being able to meet financial obligations. You can't get cash out of the operations. It's operating on fumes. The company's revolver goes into default. The company undertakes a business model which is stretched out over longer than planned. And I have to tell you, in my years in banking and my years of doing the kind of work we do now, the lullaby from businesses is usually if we had just a little more time and a little more money. And I can't even tell you how many boards we've advised and told them a little more time and a little more money is not going to do it. This dog isn't going to hunt, and you've got to shoot it in the head. So you just have to be really realistic about its opportunity.
And I might interject here, when we first see these, we being the bankruptcy group at Fredrikson and Byron, is usually at that stage, and it's very hard to fix because being out of money is a non-fixable problem. They really should have gone back quite a bit in time before they addressed the possibility that they would be out of money at the end of the term of the loan, or at the low point in their on their collateral base or whatever.
And I would say, again, my experience is that this happened, remember, boards meet like quarterly, and it happens so incrementally. And if you go back and grab the minutes and read the minutes, every quarter it was the financial report unanimously approved, the financial report unanimously approved, the financial report unanimously approved. And then you look at the financials and you see that, the receivables have been going down, the payables have been going up, the working capital has been disappearing, and the board has watched this quarter to quarter, but didn't watch the trend line. And so the next thing that happens, they're out of money. So, boards in particular, I think, have to really ask tough questions and really watch what's going on. And like I say, it happens so incrementally that it's not that one day they're going to go to a board meeting and necessarily, they're going to say, oh, good, new news, we're broke. That'll happen, but you can see it happening along the way. On the next slide, the stages of a crisis development.
So, Mark, John wanted to interject one more thought about reputational issues, I think, John Stout.
I do. Volkswagen is an obvious one, but I want to take a different side of it. I want to go back to board composition. Reputational issues can affect your board of directors because there are some people who serve on boards who are extremely conscious of their reputations. And you may find those people problematic when something comes up that's a serious crisis that they believe may impact their reputation. Those people may be the first off of a board. So you want to be careful sometimes about picking people for the board who are high on reputation, because it could be a two-edged sword.
So, Mark, shall we go to the next slide here? I think I can operate
Yeah,
this.
and again, we're trying to cover a lot of material and just kind of hit the top. But these are kind of the stages we see in typical organizational behavior. As if there's a crisis denial, again, back to this term, the denoidance that we coined, which is the combination of denial and avoidance, complacency, there's crisis denial, period. And I don't think there's anybody on this panel that hasn't sat in front of a board and said, you're in trouble, you have problems, and get pushback. The crisis gets explained away typically by management on a belief that it'll disappear again if we had just a little more time and a little more money. And I would encourage boards to really put that one under the microscope and take a look at it. Then there's the disintegration of the organization that begins, some actions taken, but it's way underestimated. And then finally, the organization collapses, and there's an inability to take action. And so then somebody has to step in from the outside for the recovery, or the company goes under. But if you catch a business in trouble early enough, you can fix it. You can fix operations, you can fix financial. You can't fix stupidity, in my experience. So if you can get to it early enough, you can fix those things. If you go to the next slide, Jim.
Yep.
The next slide hasn't come up
It's there,
yet.
it's on there.
So this is not intended to be, a treatise on the subject, but this slide gives you some idea of what the options are. So a distressed company can try a workout, an out-of-court workout, driven by the belief that an out-of-court would be more cost-effective and be effective. Or it can do a sale or merger, and that's going to be driven by the availability of, or desire of a competitor or other independent entity to take over the operations. You can go through a Chapter 11 if you have secured creditors that have inflexible agendas, or antagonistic unsecured creditors, then an 11 may make sense. Or you go to a 7, it's just driven by the conclusion that the company just can't be reorganized because of the reorganization would leave the company too weak, and so on. So just in a snapshot, these are the types of choices that boards need to look at, and they need to look at all of them, and others, and combinations and permutations of these.
So, Mark, may I interject on that then? So what Mark has described, again, when it comes to us as insolvency practitioners, very often this is the full set of choices. And it will be a shock to the directors. It shouldn't be. So maybe maybe there would be another slide before this, or another circle on here about continuing in business and solving the particular problem, and they'll keep trying to do that and keep trying to do that, and avoid looking at any of these other choices until there is no other choice, until the most usual situation now is that the bank is not going to lend any more money, period. So now, some of these may be choices, but going forward is not a choice. That is by far the single most common situation that we get, is that the bank is not going to lend anymore. The company cannot live on its own cash, what we call cash collateral, on a going forward basis. We may talk about that for a while. And the bank will make this choice. The bank will decide, usually, that there's some going concern value in the collection of these assets and the continuation of the business to some extent, and this business will be sold. Or, if even that looks problematic, this business will be dismembered. So the question is, who gets to make this choice? And if the board goes too far, it doesn't even get to make this choice.
I just wanted to pick up on something that John Stout said too. This is and Jim piggybacks on what you were just saying. This is where oftentimes you see the directors who have, they want to protect reputation. And so when you start going through this chart, you say, well, here are the kinds of decisions you're going to make. You know, this is where the bailout starts to occur. And they say, well, I want to resign, I want to get off the board. And it's tough for a board, in particular, if they don't have experience in going through a crisis. It is really, really tough for them to look at each of these, and they look at them a lot of times with the bias through the prism of how am I going to look in this, as opposed to the prism of what's in the best interest of the company. And you as a professional, whether you're in our business or the lawyers or the advisors, we need to guide them so that they are looking at this through the right prism, because I guarantee you, and John, I'm glad you mentioned it, because many times they're looking at this as which one of these is the best, it's going to make me look best. And it's a natural, I don't criticize them for that because it's a natural reaction. They've never been through it before. And you have to remind them of their fiduciary duty of care and their fiduciary duties of loyalty on the way through it. John?
Yeah, it's important just to emphasize that if you're in it, you're a fiduciary. And, but the other side of that is sometimes it's helpful to get the board down to the people who really have the experience, are willing to fight through the issues. And so in the case that I was talking about earlier, I didn't really miss the people that left. In fact, it was kind of helpful because we got down to a core decision-making group, and those people were great. And so it was really useful to have some people leave for whatever their personal motivation was.
So we had fun with this issue as we prepared for the program, and somewhere on a later slide is the word resign with a big question mark and exclamation points, and we might have put more there if we captured all the words used in our discussion, but maybe we should just jump to that. The question comes up at about this stage, and it's put to Mark if he's on the board or if he's consulting with them, or if we're in early enough, it's put to us. And Mark and I have had this question in real time, in real cases. Mark, what do you think about whether they should resign or not?
Yeah, there are times when you go into a board and you wish they'd all resign. Or you could gas the room.
Steve Jobs insisted on it when he took the job again.
Or you could gas the room or something. But I guess I go in assuming that they are all, good people, and they just don't know what to do, and they need guidance and they need direction. And look, I've either advised or served on over 100 boards, and I'm not going to see anything new at this point. I mean, I've been in board meetings where the chairman called the board to order and then opened up his laptop and returned emails the rest of the board meeting. So, I mean, I can give you horror stories about boards, but the fact is that I prefer that they not resign. And I prefer it because it is sort of a visible admission, if you will, of guilt. The counter argument to that, of course, is that, well, it was on their watch that this company got in trouble. Well, they're already a little more than in trouble. And I think we've been successful in being able to call them out by, it doesn't take long. I think John and I think everybody here would agree that after you're there for a period of time, it doesn't take long to figure out who are the ones that are going to be valuable and who are the ones that are going to be sleepers or who are the ones that are going to be destructive or disruptive. And we try to get them by getting an executive committee or a special committee or an ad hoc committee, get the ones that are going to do the job and make the decisions isolated and try to fence in the rest of them so that they don't do any damage. And we kind of give them the checklist of here are the things you do and don't do. We do try to keep them on if we can. Just maybe it's optics, maybe it's whatever, but you know, the shareholders a lot of times are already pretty shook up, and the banks and everybody's mad, and you can solve some of that problem by getting rid of some of your directors, but we also have institutional knowledge that goes out the door that I'd prefer to keep for a while.
In that discussion, then, I'll catch you in a minute, Phil, if I could add my contribution to this, because I'm brought into these discussions sometimes as well, and sometimes a little later in the process. Well, one, if everybody resigns, we're going to have a non-productive, totally ineffective organization, and you don't want that if you're in there trying to save the thing and you don't have anybody to serve the board function or the executive function. You don't want to be handling that yourself as a workout consultant. I also agree that it's more likely that the people who hang around and solve the problem or do their best to solve the problem are less likely to be sued. When somebody looks back and says, well, who's responsible for this? I think it's easier to target those who aren't there any longer and have who aren't needed to try and say what value is there. If this case goes into bankruptcy, if the situation goes into bankruptcy, then I say I have not seen officers and directors of a company that's in bankruptcy sued for actions that they took or didn't take while they were in bankruptcy, because if we're doing a reorganization, there's going to be a court order that approves almost any action that was taken that's not in the ordinary course. So if there's a decision to sell, there's a decision to make a business decision in terms of turning the direction of the company or so on, there will be a court order, there'll be a presentation and a court order that backs them up. So they're safer from that point forward. And finally, we'll get into insurance, but the rationale, one of the rationales for maintaining D&O insurance or buying tail coverage later in the process is that the people who want this continued coverage won't continue to serve unless they get that coverage. And that is some of the law, at least in bankruptcy, and if there's time, I'll cover that more, but if there isn't, you've gotten a hint of that. You go into bankruptcy court and you say, we want to spend a lot of money to maintain the D&O insurance, then the question that the judge should be asking, if somebody objects, is, well, how does this help the company? And the answer is, these are the people who have stayed and will stay, but they won't if they don't continue to have insurance.
I want to just do a quick pass over to John R. Because the issue of notice, in order for D&O insurance to apply, there are notice provisions in these policies. And the bottom line is they want, people to notify sufficiently in advance of a claim when they become aware. So what about this subject in the bankruptcy area? When should you really contact you or the agency, other agency, or the company, the insurer, and say, whoops, we're heading into a problem here and we're going to need some coverage?
Right. Well, when you get into a situation, if you think about the typical renewal application that an insured would go through, one of the questions that comes up is, are you aware of any circumstances that could give rise to a claim? And I think that's really the point where if the directors, officers, the organization is aware of a circumstance that could give rise to a claim and or you've actually received suit, is the time to start notifying your insured in order to affect coverage and to start establishing a claim notification to the carrier.
How about if you're in the middle of a policy period?
Same thing, if you have notice of a claim, there's actually a suit, is when you would, give notice to the carrier that there's actually something going on. There are circumstances that arise where there isn't been a notice of a claim, that the board of directors or the officers may be aware of a situation, and it can be either a written documentation from a potential claimant. It doesn't have to be a formal suit necessarily, but as soon as they're notified of a potential claim is really the time to engage your carrier in order to start establishing, the strategy and managing through
How
that claim.
about we just met with Mark Shefford and Jim Bailey?
And
That question, I'm not sure what it is, John, either, but maybe it is just that we see the company in worsening financial circumstances.
People aren't going to meet with you if they don't see issues, is my point. When you get called in, we've already got some serious problems.
well, I'm living through a real experience right now
Yeah.
with this, with a client where we've had 4 years of declining financial experience. We're stepping back and thinking that what we need to do with the organization, that we need to do something in addressing the financial experience. We've had 4 years of cuts, and we've come to the conclusion we can't cut ourselves to success, and that we need to take a direction. Now, is that a circumstance upon which that we need to notify the carrier? I don't think so at that point. We're addressing the issues with the company, but it's when the saber rattling starts happening and a third party starts raising, we're going to sue you as a director and officer, and they start putting notices on. That's really the time that you need to notify your carrier.
And I would hope that the company is willing to seek advice at a much earlier stage than the almost, uncorrectable crisis that we could participate in the discussions about what the alternatives still are and how to keep those alternatives open, and how not to make a serious mistake that will will close options later on. A really good example is, so there's a problem with a bank and they want to give a forbearance agreement. And counsel isn't part of that discussion, and the bank wants the company, to waive all defenses. And by the way, there's some additional collateral that somehow didn't get picked up, and now for a 30-day extension or a 60-day extension or some waiver of some relatively smaller covenant, all of the ammunition for a turnaround is gone.
I think we have a slide later on. Maybe it's worthwhile spending a little bit of time on this issue right now, but don't forget all the advisors that you have around you as an organization. Oftentimes, directors and officers are kind of inside the company looking at things and having access to external advisors, your law firms, your turnaround professionals. Reach out to those people. They can provide a lot of good insight and understanding of the situation that you may be heading towards, and getting that advice early on is always more important. I think that's the thing we all try to manage through risk, is anticipate risk, manage through the risk, rather than wait for it to hit you in the head.
Okay, so I'm going to change the slide here, and Mark, there are two more that address generally how the board should think about the problem and financial considerations and so on, and we're not going to have enough time for everyone. Your judgment on how much coverage to give these next two?
Yeah, I think, again, let me do this a different way. I don't think, at least I think John asked a great question, when we get called in, the board usually now knows it has a problem. But there are times when we get called in, and Jim knows this too, we do an assessment because the board doesn't know the depth of the problem. So, we try to look at what are their options. Typically, the boards are terribly afraid. They're afraid for the company. They're afraid for themselves. So, we need to try to help them through that. And one of the ways we do that is look at what are the financial aspects of considerations. What's the liquidation value of the company, the cash flow projections, the value of your intellectual property? Are there recapitalization possibilities, the sale of divisions, units, subsidiaries? you gotta remember, the board isn't thinking like this up until this time. Many times they've been told that things are just fine. There isn't a crisis, there's nothing that we can't handle. And all of a sudden you find out that boatload of equipment coming from China sunk and you don't have inventory anymore. So, what about the sale to company? I won't get into time and timing issues. I will say, though, that I think we have a responsibility to try to counsel boards through these options and counsel them through these considerations and try to give them a different perspective than the one they have at the moment, which is fear. I mean, they are afraid. And as I said, they didn't go on these boards because they had deep experience in crisis. They went on these boards because they were invited as a result of their success in being good CEOs of companies. Okay. The next slide, the board's role in a crisis, I think we already talked about it. You can usually accept, our experience is that where there's smoke, there's fire, and so accept the fact that it's probably worse than you anticipate. It's a hard piece of news to give a board, but it's reality. And accept that it's real. Don't confuse the causes with the symptoms. This next statement, take control. The old story is for boards is fingers out, or noses in, fingers out. We believe that when a company is in distress, that the board needs to be a little more fingers in. Not necessarily run the company, although the board may want to bring somebody in from the outside to do some interim management. But the board has to take control. The board has to now start meeting. Boards, instead of meeting quarterly, we tell them you've got to meet weekly. Defer compensation. Don't take compensation as a board. Demonstrate your commitment. You need to behave entirely different than you have in the past. Know the duties of various stakeholders and that those will change. Jim's going to comment on that. Those will evolve a bit in insolvency. Obviously, if you have a crisis plan, execute it. And I can't, again, emphasize enough the importance of having a crisis plan. One comment I would, and then I'll get off of this, but when you look at the duties in Minnesota, the statutory or the requirements, the duties of director in Minnesota, and John Stout talked about this, but boards today aren't getting sued for a breach of duty of care because there's no money in it. It's exculpated, business judgment rules. It's all on the duty of loyalty. So was the board, did it protect confidences? Did it communicate? Did it disclose? Did it do anything? John, you're the expert on this, but to breach the duty of loyalty, because that's where their exposure is. But sometimes we've gotten to boards and they've either read now or somebody told them you have all these different exposures. And of course, what we really encourage them to do is get legal counsel immediately and get the clarity about what their real exposure is.
So that's the cue. To me, although I just go back and pick up 2 lines in the slide 2 back. When we get into a situation, I wish that there's also a financial advisor, and I'm looking at some of the audiences in the picture and on the dais here, who have made a liquidation analysis and done a cash flow projection that extends some period of time. I just don't think you can think about these problems, including how to apply what the duties of directors to some particular decision until you have that piece of information. If you shut the business down to right now, today, what dollars are available and what claims are there against those dollars? If you make decision A how will that change? You'll expend a certain amount of money, so maybe there's less cash available, but maybe inventory has been turned into accounts receivable, maybe the liquidation analysis goes up. You're now having to analyze decisions in terms of what the liquidation analysis looks like. And the cash flow tells you when and where you have problems. And so the company, financial people are used to projecting on an accrual basis leading to the accounting statements, and they typically won't have a cash flow analysis that actually applies to their situation. So now, I'm going to go back one here. So when we were preparing for this, I got into this next section, and Mark kept saying to me, so what's your point? So I came back to the next session and tried again, and he said, so what are you trying to get across here? So this is my third effort, and so I trying to put the answer to that question next. I think I've got the right one here. So, go back one. What I'm going to do primarily is go through a discussion of the evolution of the law on the question of whether or how the duties of officers and directors change and the exposure that they have over time. There are cases all over the country and all over in time which would say almost anything on this subject. So it's hard to figure out how to synthesize that. So I'm gonna try and do that. And primarily what I'll do is cover that by talking about the Delaware law and where it was or could be said to be in about 2007 and where it is now or is said to be in 2016, which is full circle. In each of about 6 or so important points, Delaware has disavowed what had been said of its law. And so you could say, all right, so we just want to know now what the law is now. Why are we going to go through this history just because Jim Bailey's interested in it? And he has all this information that might otherwise be useless. One answer to that is that Delaware law is not the law everywhere. So there's case law out there in other states applying the corporate law of other states. And so you may directors may run into this problem just because you'd be protected by a Delaware court, maybe. In particular, these concerns or principles that are the older law are still the law in many other countries. So I'll try and remember to tell you that the officers and directors may be fine if they're operating a Delaware company and being heard in a court in Minnesota or Delaware, but what happens in France or Germany or some of those other states, other countries, could be very different. The law has changed, but it could change again. So some sense of its history could help us. But I think mainly it's because the old laws tell us, these old cases tell us the area of sensitivity. If you get into an area where sometimes courts have said there should be a D&O liability, you need to become extra careful. And these also define the areas, if not before, that there's a much higher level of care. So that now records are better than they were before. Process is more complete than it was. The questions are faced up to and answered. Experts are retained and relied on because we're now in the area where you may be getting close to some potential liabilities. And the other thing is, Mark made a very good point here, the business judgment's going to be available, one hopes, to protect on the duty of care, but it's not going to be helpful on the duty of loyalty. And so this is the area where everybody needs to be much more aware that there's potential danger here And loyalty issues have to be looked at constantly. So what is that full circle? In the next slide, yes. Before 2007 or so, each of the statements on the left-hand side were a statement of Delaware law or could be predictively said to be Delaware law, because there was some case in the Third Circuit, for example, that said, well, we have to evaluate Delaware corporate law. They haven't answered this question. This is how we think they would answer the question, and that becomes big news. So, first point, duties run to creditors. There are cases all over the country, including in Minnesota, that say once a company gets into an insolvent situation, the duties now run to creditors. And those cases aren't repudiated, which led to a discussion. Does that mean instead of shareholders, because the primary concern of the board is to try and get a good recovery for its investors, for its equity, now has that changed to so that duty runs to a different group instead, and what are all the consequences of that, some of which we're going to discuss now. But the Delaware courts have now come around to say what John Stout just said, and that is, well, we're going to, as far as I'm concerned, avoid this question by deciding it runs to the firm, which is to everybody. And so we won't recognize a distinction there. Just decisions need to be for the best interest of the firm. But I'm telling you that if decisions are made which are clearly only for equity, there's going to be trouble. So the example I always use is just be really silly here. Can the board take all of the remaining cash and buy lottery tickets? That could work out great for the equity, but those dollars, had we liquidated then, would have been available to the creditors. If the board makes a decision which extremely tilts on this point, we're in a situation where there's a real division, then I think, there's some potential for trouble. So this is an important principle to keep in mind. Although courts are quite protective when business judgment is being used, if the consideration runs to the firm. So some courts have said, and it could be said of Delaware law at one point, well, if it's true that it runs to both the creditors and shareholders, which many people have said, well, wait a minute, now we have a conflict in interest. Some situations, like the one I gave you, require that the board choose. And in choosing, is it disadvantaging one or the other? And if that is true, does the decision have to be, quote, entirely fair, which is a higher standard and which bypasses the business judgment rule? Now you're in what looks like a conflict, and the board may be held to a higher standard. There are such cases, but the Delaware courts have recently said in this period between 2007 and in several cases, Trenwick and Gowalla in particular, Quadrant more recently, that there isn't any conflict. At least they say there isn't any conflict, and the business judgment rule applies. Some courts have said, in particular cases, that in this situation of insolvency, the board and the officers are acting as a fiduciary, that they manage the assets of the company as a trust fund for its creditors. It's usually combined with the concept that the interest now runs to the creditors, and that invokes a higher standard. What they say and what they sometimes mean is the kind of fiduciary that would be the executor of a will or something. That is, that great care has to be used. Conservatism would be the appropriate standard, not a standard that you would normally apply to the ongoing operations of the business. So there is case law to that effect, which has been explicitly disavowed recently in Delaware, and there are Minnesota cases to the same effect. So now the question of deepening insolvency, which people find intriguing, I find intriguing. is the idea that once a company is in trouble and insolvent, the officers and directors can't run it in a way which deepens the insolvency, makes the situation worse, keep spinning your tires. Which carried to an extreme would freeze them, right? Because the potential is, no matter what you do, if things turn out worse, no matter how good the judgment is, if things turn out worse, then the application of a deepening insolvency standard could apply. So Delaware has recently said, no, we never said or meant that. No deepening insolvency here, understanding that this would be the end of officers and directors deciding to incorporate under Delaware law, if that's the exposure they have. But I'm telling you, it is alive and well in many European countries. Officers and directors of a French subsidiary or German subsidiary would be well advised to get good advice on that, because they are treading in a risky area up to and including criminal prosecution, especially if employees don't get paid as things finally turn out.
And by the way, if you take this to non-US jurisdictions, and quite often those subs are run by the officers of the company, they serve as the directors. There often aren't any serious number of outside directors, and sometimes no outside directors. You better call your insurance agent or your insurer quickly, because there are countries which don't recognize indemnification, don't allow D&O insurance, or don't allow your particular carrier, if it's not licensed or dealing through a licensed carrier, to use insurance. I mean, you really get off into another area, and you've got to pay really close attention and get some good advice from your agency or from your insurer on that subject.
So the zone of insolvency, if these things that I said are true or might be true in some circumstances or some states or countries when the company is insolvent, what happens if they're almost insolvent? They can see insolvency from where they are. So there are cases that say that the same principles apply in the zone of insolvency, which is especially frustrating because how do you define that? Insolvency is hard enough to define. What's the zone of insolvency? So there are not many cases that impose liability in that kind of situation. And once again, the Delaware cases currently say there's no such thing as a zone of insolvency in their state. We never meant that. And then finally, if duties do run to creditors, can creditors bring direct lawsuits against officers and directors for violating their fiduciary duties as they run to those creditors in a direct action? And there have been some number of efforts at that. And in Delaware, they say, no, there's no direct action. No individual creditor or group of creditors could bring such an action for a breach of fiduciary duty running now to creditors. You could say maybe they never would, because now it doesn't run to them separately. It runs only to the firm. But actually, they do seem to recognize, a derivative action. So creditors can seek to bring a derivative action in Delaware by the usual rules of derivative actions. And so that possibility still exists. And there are several recent cases that try and address those issues. Now, Minnesota law is not, next one, you got that, John?
Yep.
Okay, so Minnesota law is not nearly as fully developed. They never took the frolic and detour into all of these areas that I just described. But the most important decision is Schneider Electric case, which says the directors of, quote, financially embarrassed firms have a duty not to prefer themselves. And so there are many cases in which it is asserted that the officers and directors manage to somehow get themselves paid first, or their companies, or their interests, or their status, their type of investment, or whatever. That is a real risk, which underlines, again, it's a loyalty question. If it's just a matter of care, it's one thing, but if they're now taking their own interests ahead of others similarly situated, or others who get to participate in this, there is a real risk of liability in there.
And that's a D's and O's issue.
Yes. So another case is said in the second line there, the duty to preserve assets for creditors is limited to not making these preferential transfers described. And the trust fund doctrine explicitly rejected under Minnesota law. So that's a quick turn. Yep. Question.
Jim, I just have a question. When you look at the duties of officers and directors as you consider them in insolvency, isn't the obvious answer to seek the protection of the courts rather than tread through, are we going to be so issues? My
Yep.
limited experience, by the time you can see insolvency around the corner, you're insolvent.
Well, that's I think, a good point and a real consideration as somebody who's not afraid of bankruptcy or some kind of proceeding. I would say, yeah, you shouldn't be quite as afraid of that as you are. And one of the things on the positive side is you will now be getting a court order to approve all of the important decisions going forward. But of course, they're balancing considerations. They frequently fear that the vendors will never sell to them, and the customers will never buy from them, and they will all suffer reputational risk. So there's a lot of resistance to doing that, and there isn't a single right answer on that question. So I think we go to the next slide, and here we got some other, what you might call, I put quotes around the idea of duties. To exercise care or loyalty, here are some examples. And I think, Mark, they're your thoughts, I think, or did you want to run with this slide? Or
I think in the interest of time, I think we've covered these, unless you guys have something else you want to say.
Okay, well, let's go to the next one then. So we see.
Jim, I just want to make a quick comment. As you go through these things, there's always a debate, or not always, but in some companies, there's a debate. Some people are minimalist in terms of the minutes they like to keep, and some people are maybe maximized, but there's a balance here, and I'm not a minimalist. What I think the directors and officers need in the way of corporate minutes is minutes which clearly show that they're doing their duties. And so while you don't need transcripts of meetings, you really should pay attention to the minutes so it's clear that you're, following the duties that we've been talking about this morning, and you're providing evidence of that. By the time you get into litigation on this subject, several years may have passed. And if you're not clear in the minutes, people can use their own recollection, such as it may be, from the vantage point of how does it serve my interests? And there's no reference point. So if you read depositions of directors that have been through this, which I have, the stories are all over the map. And it really sometimes just depends on fading memory, and sometimes it depends on whose ox is being gored, 3 or 4 years later. So really pay attention to your corporate minutes and get some good advice if you're struggling over what ought to go in and what should not.
So here,
Go ahead.
yeah.
Last summer, the Court of Appeals announced directly that directors owed fiduciary duty to creditors in an insolvency situation. That's in Jack Walzer's case, the Motorworks case. And review was denied in that case. And that was his own insolvency case as well.
Yeah,
But it was a preferential transfer case.
yeah.
So how are we to read that? Is that a broader statement of the duty than was necessary? Because if you read that case, they clearly owe it to the insolvency directors owe it
Yeah, I haven't read that particularly in preparation for this meeting. I had interpreted that primarily as a self-dealing situation with, somewhat loose language, but I think it underscores the point that these other principles, which have not generally been adopted in Minnesota, represent areas of some danger. We can't be assured that they will not on a particular set of facts.
Jim?
Go ahead, Mark.
Yeah, this is just a real quick thought, but I want to go back to, and John, you may want to jump into this, or Jim, on the business judgment rule. It's really misunderstood out there. For instance, we went into a company where it was upside down, and one of the directors had brought in his son, who had some financial experience, to look at their options. We said that was probably not a good idea, and he wasn't really qualified. So on the business judgment rule, while there's a lot of protection and people tend to run and think they can hide under the business judgment rule, one of the keys is to make sure the board makes sure that the people providing them with input are qualified. They really have to be qualified, because if they're not, you're not going to be protected under the business judgment rule. I mean, you have the right to get information. You have the right to rely on the input from experts and from management. But if they're not experts, they're going to get challenged, and if they get knocked out, you have exposure. So when you're advising your clients, and John, I'm sure you run into this, I mean, you want to make darn good and sure that the people advising the clients are in fact experts, and that the board has discharged that part of its duty.
So we knew when we began that we wouldn't have enough time. So my judgment is that, John, we should get to the second half of your presentation and then come back and let us choose among us just a few things that we still think we should hit.
Right, and so my end here is really just, we were kind of touched on it already in the earlier conversation, but typically in the process, once the bankruptcy is completed, a tail policy is purchased, typically approved by the bankruptcy judge, and then a new policy is issued for the ongoing concern. So it's a process that typically goes through, typically approved by the bankruptcy court. So that's really, I think, what we want to touch on real quickly at that from a process standpoint. And again, thinking in terms of the new policy, you just go back to the beginning of my slide, think through the process, think through the limits, think through benchmarking, what's the new company going to look like to make sure you've got adequate limits and the right kind of coverage.
All right, so we have a recommendation. Well, let me ask Mark if there's one or 2 points that you would most go to. John's suggestion is we go to living through the crisis and hiring the crisis advisor. Would that, should we take that one next? Unless, Mark, you want to interject with something else?
So again, we've already commented on some of these, but we'll just do it again. But the board's inexperience in a crisis situation it's difficult sometimes, again, to deal with it, and you have to kind of be patient. I mean, I literally have had board members break down and cry, meetings with them, because they're afraid of their reputation, they're afraid of what's going to happen, they feel like they have let the company down, they didn't stay on top of management like they should have. The emotional impact is huge on an organization, it's huge on a board, and I think we need to guide, like I said, guide them through having a plan and making sure that they pay particular, John talked about this in the minutes, but make sure they're really paying particular attention to ongoing governance. In terms of hiring the right professionals, there's a list here of kind of characteristics that we think are important, and I think it's sort of self-explanatory, but whether it's the lawyers or the bankruptcy counsel or CRO or a turnaround or interim management or whatever, we think these are important characteristics that they need to have as a part of the turnaround. I just have one final comment again. that directors are not emotionally prepared to are not prepared to deal with a major crisis. Most of them have never had to do that. And so when you meet with a board and you get this sort of look on a deer in the headlights look, which we get many times, over the years I've learned how to overcome it. And I couldn't understand it at first, but now I understand it. And even in our colleges and universities, the MBA programs, they're not teaching how to operate in a crisis. So this is where the learning takes place, or in seminars like this.
Okay. Yeah, we should go to questions. Back to Phil on your MotorWorks case here, which I have, and I'm refreshing myself. But the main head note there, not to undercut the point that you can find support for some of these principles in the facts of the case, or even the language. Director's self-distribution of corporate funds that renders the corporation unable to satisfy a pending claim of a corporate creditor is a breach of the director's fiduciary duty to that creditor. And so that language is a little loose, but I think what really drives that case is self-dealing.
Well, I think that those are the facts that command the outcome. The principle stated in
Right.
would suggest that fiduciary duty is over. They say it.
Yes, yeah, they do.
in the body of the opinion.
Right.
But I agree. That's what Jack Walter did in that case. Was going to lose the case every time.
Right.
Get the principle of law.
Right.
That's for sure.
Yeah, but you're right, and worth noting that there's language there that could be used in another situation where the facts are a little uncomfortable as well. So let's open it up to other questions.
Let me ask this question.
Sure.
Most D&O, if not all, of it's kind of claims made.
Correct. Yep.
And therefore, giving notice of the claim is a critical step to having a handle on recovery.
Yep.
No carrier is going to accept or report that the company is in financial trouble as notice of the claim.
No, correct.
But they may find that there's a reason not to renew the policy.
Yes, they can. Yep.
It can also be a pricing issue.
So I think you do have to look for something that justifies the claim.
Correct.
So you get a handle on coverage. You got to be careful of not talking yourself out of a new policy.
No, I agree with that 100%.
They're not going to write coverage on a failure claim.
Well,
But
the
they
other-
do
sorry.
get financial information as part of a renewal process, so they're obviously aware of what's going on from a financial standpoint to a certain degree, but exactly, yep.
But you saw on one of the slides the notion of investigations, and in some policies, you either by endorsement or direct language, you can get coverage for certain kinds of investigations. And so it's worth, I mean, this issue of when you notify and what you seek is, of course, policy language dependent, but it's also, you get into some of these gray areas where you need to consult with, people like John and others.
Other questions? I will take just another minute or so on the question of what happens in bankruptcy, because we've wrestled with this a number of times. It can be expensive to renew the policy. And there's danger to officers and directors. The claims will be brought later based either on situations that occurred at some earlier time or during the time period that we're talking about. And so there's a wish on their part and the company's part, although the company maybe doesn't have much of a will at that point anymore, to keep that coverage, and it can be expensive. My view is, this is one of the reasons to think about the situation as early as possible, because renewing policies using corporate funds is more defensible earlier and less defensible later when maybe the last dollars are used for that purpose and some question of loyalty could be raised. My tentative view is, though, that once in bankruptcy, it may be necessary at least to purchase a tail. I'm not sure about renewing a policy in the ordinary course, but is that decision in the ordinary course of business and doesn't require the approval of the bankruptcy court. That would be a safer action. And I've kind of wrestled with that a little bit and sometimes made that motion. So far not resisted, because I think if there are people who want to sue, they actually want those policies renewed. And somebody who may be a trustee or represent creditors, if there are going to be claims, want those policies renewed. The other question, as I said, if there's really a chance of reorganization or restructuring, then are those officers and directors needed to complete that policy? And if their insistence is that coverage be continued, then that's a pretty heavy weight on that side of the scale.
I want to make a quick comment relative to the Volkswagen matter that was mentioned earlier. I did a panel for the business law section in Montreal a couple of weeks ago called From Enron to Volkswagen, and it had to do with crisis, but it had to do with corporate culture. It had to do with a whole bunch of things that Volkswagen raises. But to the point that has been made and was made by Mark earlier, that sometimes you don't know what you've got your arms around, and we were talking about communications and all of that. If you remember, the beginning of that case was the estimate was $3 billion. Volkswagen made an early estimate of $3 billion. It then went to $7 billion. It then went into the teens. The most recent estimate I've seen is $50 billion in terms of the costs of that. So you can imagine being a director and trying to get your arms around exactly what the exposures are. And to the point of communication, you may remember that the CEO of VW North America made the comment that it was 2 or 3 rogue engineers who installed this, and nobody else in the company knew what was going on. That will turn out to be totally false and a totally misguided communication on the part of that president, who, by the way, CEO is no longer the CEO of North America. But it does kind of underline, hopefully in a crisis or a situation that none of us will ever face in terms of magnitude, the challenges of communicating before you know what to communicate, and the challenge for a board of going, of getting your arms around the totality of the crisis. And then for directors, of course, in the financial crisis, supposedly the Citigroup directors met once a week, and sometimes more than once a week. They had 50+ meetings in the year when that crisis really bit. And imagine being a CEO on that board with a full-time job at another company, right? And taking that kind of time away, which again goes to board composition issues, but it also goes to what happens to your board when you end up in a crisis that demands that kind of time, and who's on your board.
Can I?
Yeah, please, Mark.
I wrote an article on the Volkswagen situation, and I always get a kick out of John's comments on these, that, the Volkswagen board is an inside board. It's an insular board. And I mean insular. If you're not in the Porsche family or close to it, you're not on the board of Volkswagen. And even when the chair and the CEO were booted, what did they do? They brought in 2 more Porsche folks on the board, despite everybody telling them that was a huge mistake. One of the things I found out about Volkswagen and doing my research is that Volkswagen started as a result of Adolf Hitler saying we want a car for the people, and they created that. They used them for troop carriers, lightweight troop carriers during the war. But their mission, and it's a well-hidden mission, is totally to create jobs for Germans. That's their mission. They have a glitzy 25 little page value statement that they put out that if you compare that to their behavior, you wonder who wrote it. But to John's point about no if you're on the board, know what your risks are and so on. I would suspect even in the Porsche family, people that are on the board, they're scratching their head saying, how in the heck did we get ourselves in this position? But if you're those supposed rogue engineers, and you took that even to the CEO and you said it's going to cost us $50 billion to undo this deal that we did, and we're going to learn, and most important, we're going to lose a lot of jobs in Germany. Guess what the decision was? So, the board has some culpability in this. They haven't been called to account yet, I'm not sure. You know more about that than I do, John. But
Well, it's clear that the decision-making goes all the way up the chain.
yes.
This is not left at the engineering level. Interestingly enough, the whole company is made up of engineers, and including the leadership. So as this comes out, it'll be clear that this went all the way through the organization. It was not a few people that were misguided in their attempts to keep sales high.
And you contrast that, and I'm done, then you contrast that with what Tylenol did back. I think you'll remember there were 7 people that took ingested cyanide in pills that had been tampered with. And Tylenol had to make a decision what to do, and they recalled all of their Tylenol. Cost them $100 million back then. That was a lot of money. $100 million is what it affected them, and their stock plummeted. But a few days later, their stock went back up because they became the standard bearer for good corporate ethics. The board did, and their board, when asked, why did you do that? They said, because those are our values. That's what we live by. It says that we'll take care of our people and the people who serve their people.
So far, I think the customers who bought the affected vehicles have is it a $500 credit?
It's a $500 credit and a $500 credit for
Right.
fixing your car. So
Yeah.
it's $1,000 per car. I got 2 of them, so.
Not going to meet their standards, I don't think. John, maybe if there's no more questions, a closing comment. The program that John moderated has fascinating materials, and if some people want to follow up on this, if you let either John or me know. The most interesting to me was a person who had lived through really serious, as in-house counsel, really serious crisis, who took the trouble to evaluate a large number of the most notable corporate failures hence the title, from Enron forward to Volkswagen. And all of those ultimately resulted in serious studies of what had gone wrong in that situation. But by the time that came out, probably most of us were on to the next crisis, so they didn't get the attention. And synthesized those reasons into a comprehensive list of, when there's been a serious problem, what was it that caused that problem? What went wrong?
22 common denominator.
And that is, really fascinating reading.
By the way, he's the current general counsel of Abercrombie and Fitch, but prior to that, he was the general counsel of Freddie Mac. So he's seen some issues. The other person on that, there were 4 on the panel, but another interesting person, they were all interesting, was the North American general counsel for General Motors. And he actually had left General Motors before the ignition switch rose to the top, but he certainly understood the cultures, and General Motors had other prior issues. So you had 2 people who had deep experience in these issues that were remarkable panelists.
So with that, unless there are no other questions, we ended, I think, almost exactly at 10 o'clock. We didn't end early as suggested, but we're within the original time range. I hope you've enjoyed the program. Thank you.